Afternoon and welcome to this afternoon's webinar, Pensions and Family Planning on Divorce. My name is Graeme Fraser and I'm head of the family team and a partner at OGR Stock Denton. I'm delighted also to introduce Mark Penston, our co-speaker today from Bluesky Chartered Financial Planners, who is also going to say a few words by way of introduction. But before doing so, I would encourage anyone who wishes to raise comments or queries to use the Q&A or chat feature at the bottom of your screen. Over to you, Mark.
Hi, Graeme. Now, the first failing we've got is can't forward the slides.
Right.
One moment. There we go. There we go. Excellent. Sorry about that. So, hello, as Graeme says, I'm a partner of Bluesky Chartered Financial Planners for many years, probably 20 years now. We've been doing pension sharing reports and probably more latterly shadow expert work for matrimonial lawyers, mediators in the main. Graeme and I are going to talk about what we do and don't do. I've got a few slides as a reminder on the Pensions Advisory Group publication that recently came out. I ran a seminar, webinar recently on the markets and how the markets have been affected by the recent coronavirus episode. So I'm just going to recap a few bits on that. I'm then going to talk about pensions and valuations, and we're going to wind our way through various subjects as we go through and finish up with just a bit of a summary.
Thanks, Mark. Just going back to point 2, just to confirm what I do and what I don't do, because that's quite important with this area of work, because we must be careful not to do the work we can't do. My role as a family lawyer is to advise clients in relation to the financial remedies on divorce in this context. So I will spend my time identifying assets, ensuring they are properly quantified, and advising on the structure and amount of the award my client will receive. What I don't do is provide financial advice. I'm often asked to do that, in fact, but if I do that, without the appropriate qualification, I would, as I understand it, be a criminal offence. So we mustn't do that. And that's why people such as Mark are so important in our work, and we need to identify when we need to use them. Back to you, Mark.
Great. Thank you very much. So a little bit about what Bluesky do and what we don't do. As I've mentioned before, we primarily do, or our history is we do pension sharing reports. The PAG report talks about the difference between an actuary and an IFA, and really answers that question by using this term pension on divorce expert, or PODE as they've shortened it, that in many ways it doesn't really matter whether you use an actuary or an IFA as long as they are a pension on divorce expert. And the definition and the criteria of a pension on divorce expert is actually in the PAG report appendix, I think it's appendix D, where if you're using someone, you can ask them whether they satisfy those criteria. We do a lot of shadow expert work, which might be where you've already got a pension sharing report, and you perhaps want to engage with someone on a single basis, just to help you through what the actuarial report means. And because we're financial planners and can input financial advice, we can help you through with your client as to what the best offer is that might be in the actuarial report. We also test offers. So if your client is considering making an offer or they're receiving an offer, we can kind of put that into context. We use a lot of cash flow forecasting and software to help clients understand what their financial future might look. I mentioned about reviewing other people's pension sharing reports, and as financial planners, we can then go on and help you or help your client implement the share that's been agreed. I mentioned about we do pension sharing reports, but not all types. I'll come on to that in a minute. But I think we're best used. We are different from actuaries in the sense that because we're financial planners, we can talk to individuals about how their pension sharing fits into the context of their overall financial situation. We see quite a lot of work that comes our way, which is multiple schemes or high value schemes where there are lifetime allowance issues. And actually on our website, there is a case study where financial or the correct financial planning input can save a lot of money when sharing high value pension schemes, to make sure that you implement them in the right order and how much money you can save. So we do a lot of that. I've mentioned about doing shadow expert work. The point 6 is, I say it with a bit of trepidation, that we do, we will consider fast track cases. If you've got a hearing coming up and you haven't had time to get a pension sharing report done, or you want a bit of guidance, if you talk to us about what you've got, what you're looking to achieve, we can extrapolate data, use our knowledge to get you to a place, not in all cases, but in a lot of cases, where you can at least turn up in court if it gets there with some kind of guidance on what a reasonable offer would look like. But just touching on what we don't do, because we're fortunate enough to be very busy with the pension sharing work we do, we've decided to limit the work we do and generally only take on those cases where we feel that financial planning input can add value to the pension sharing report. And therefore, as this box tries to describe, if the pension share is likely to come from a scheme where the only implementation option is an internal membership, then we refer on to actuarial services, the David Lockett, George Matheson, Excalibur, and so on. Those cases will be, in the main, where a share, when you've had an initial assessment of the case, where the share is likely to come from uniformed services, so police, fire brigade, army, teachers' pension, NHS, or local government, because really all the pension sharing report does is work out how much of that scheme should be shared, and on implementation, the spouse will become a completely separate member, but an internal member of the relevant scheme. And we don't feel we can add much value. So as part of the limitation of the work we do, we don't do those sorts of cases. If I revisit PAG, I did a webinar just on PAG some time ago, but the points that, having read through PAG report, and it's full of nuggets, in my opinion, and is a must read because more and more judges are quoting from it. The main things I pull out of it is, and it is biased towards, these are the reasons why you should use, why you should get a pension on a pension sharing report, is when you first get the paperwork come across your desk, how do you know if what you're faced with is even fair or correct? That's one reason why you should use a pension on divorce expert. How do you know that, or how do you assess if a pension sharing report is needed? We haven't got time to go through all that stuff now, but it talks about that. If a client doesn't want to get a pension sharing report done, get a disclaimer done. Now, the PAG report, the final version of the PAG report, removed their disclaimer. We have a disclaimer on our website. So if you go to the Bluesky website under resources, there's a disclaimer there. It comes with a big caveat that we're not legal people and you are, so you just need to make sure that it ticks the boxes, but it's a bit of guidance as to what you might want to consider. big point in the PAG report that it's so easy to stray into giving financial advice. Even the example they give is on the pension sharing annex that you complete for your client. There is a box if on implementation, if you could share internally or externally, and if you tick that box with either box, whether it's an internal transfer or an external transfer, by implication, you've just given some financial advice to the client. So you've just got to be very careful in those situations that you're not, wandering into the financial advice land. It talks about negligence claims, which I'm sure we all know are on the increase. Most of these claims are around offsetting cases, which are, things like, the husband keeps the pension and the wife keeps the house, and that might seem fine at the time, but the passage of time, people might reflect and say, well, actually, that wasn't a fair scenario. And finally, don't close your file until any share has been implemented. We deal with cases sometimes that come to us, nearly a decade after the agreement was made and nothing's happened. So it's the view of the Pension and Divorce Committee that you shouldn't close your file until the whole case is done and the client has gone off and sought financial advice about where their shares should go. And finally, I mentioned before about more and more of we're seeing more and more cases where judges are quoting from the PAG report. There's a couple of links here, and I think someone asked, will you get the PDF slides? I imagine you will. But there's one I think is a very well written case by that Hess judged, and he's quoted lots of stuff from the PAG report. I think that to me is really well worth a read. So as lawyers and mediators and barristers, I guess you need to become familiar with the PAG report because it's going to be quoted to you on an increasing basis. I mentioned before about testing an offer. The whole movement, if you like, of cash flow modelling with financial advisors is on the increase, and we've used it for many years with our, if you like, general financial planning clients. But in the divorce arena, some clients may come to you thinking of divorce, and they don't even know how the finances are going to pan out. They don't even know whether they're going to take that. Can they afford to take that first step? Well, we can help run through that with them. We can help model it. We can help model if they've got as far as an offer being made. Is that offer good enough? And very briefly, actually last week I did 2 webinars on cash flow modelling in divorce, which I think will be somewhere on our website. But this is very simply what one of the screenshots of cash flow modelling looks like. And if this was a divorce case and this included the pension income from the pension share, you would see that in this case, the client's got the cash flow model's gone red. They've run out of money at about 80-ish. And it can get a lot more complicated than this, but in its simplest form, that's how it looks. And this is a fantastic tool to be able to go back to the other side to say, well, actually, that offer isn't good enough. And if that is the offer, because that's what the pension sharing report says, or you can't negotiate any harder, then the cash flow modelling is still a great tool to set the expectations of clients. Maybe look at revising expenditure needs. Maybe look at working for a longer time. All the different permutations. So it's just a fantastic tool. We see lots of clients just going boss-eyed like a rabbit in headlights when you show them a table of figures. If you show them a graph and you can explain the graph and you can work live with that graph in front of them to test different scenarios, it can bring the whole financial future and the whole financial position into focus. So I think it's a hugely helpful tool. Markets in context. So this again is a very brief summary of a webinar that I ran before on where the hell are we going with the markets. Well, of course we don't know, but to put it in context, this is the FTSE. Well, it's effectively the FTSE, it's UK equities going back to when records began. And you can see that there's ups and downs, there's volatility, but the general trend is upwards. If you sort of analyze and extrapolate economics and the whole reason of investing into equities, then generally it's got to outpace deposit rates. We've seen a big impact around coronavirus over the recent few months, and if I just looked at a graph of how the markets have performed over the last 12 months, the blue line is the FTSE, and you can see that at its worst, the FTSE fell by over 30%, has just recovered by it's down about 15% now. And of course, lots of your clients might come to you with sound bites that I don't want to pursue this divorce at the moment. I want to sit on my hands because the markets have crashed and the FTSE is awful, and all these reasons to prevaricate. And what I wanted to show with these other three graphs is these graphs are pension managed funds. Now, clients might think that the bottom has fallen out of their pension funds, but in the main, these pension funds will be diversified portfolios. They won't just be invested in the FTSE, which is a very concentrated index. They'll have internationally spread, geographically spread investments. And just a little bit of advertising, I suppose, but my apologies, it shows the point, is we run some investment portfolios for clients, different portfolios 3, 5, and 8. They're just selections of different attitude to risk. But you can see across the board, pension funds haven't fallen as much as the FTSE. So clients who are worried about this should have it put into context, because generally they're more likely to be in a well-diversified managed fund than a FTSE. So what that graph does show as well is over the last 12 months, values have recovered. We're almost back to, well, we're just ahead of where we started. No reason to defer, but even if the market had crashed, then remember that if you are implementing a pension share, then generally you're selling low, and then you're buying low when that share is implemented into a pension of the recipient's choice. There is a very slight warning that projected incomes, we're seeing in our pension sharing reports, projected incomes are a little bit lower because annuity rates have dropped a bit, because underlying gilt rates have dropped with falling interest rates. They are, to a degree, interlinked. Now that's defined contribution pensions. I haven't really mentioned defined benefit schemes because in the main, they haven't changed that much. Most of the questions we get are around defined contribution pensions where there's an invested fund. Graeme, I think this is you now.
Yeah, that's very reassuring to hear all of that, Mark, actually, because I think it's the first time I've heard anyone provide calm advice about what's going on, because I'm just reflecting now in terms of how I've been seeing practice since the lockdown, and what are the things that lawyers are getting inquiries about, and what we're seeing in our casework. And I think one of the things we are noticing is the concern about changes in asset values. Obviously on your graphs, Mark, we did see sort of zigzag patterns and really concentrated. And I think it's really been accentuated. First of all, we had Brexit, and now we have the virus outbreak. And the impact for us is where we see volatility for shares and in the property markets. And that's almost only on a weekly basis from what I've seen. Now, in terms of how we see this in the law, and the reason why cases are being monitored or reviewed or new issues are coming up, is because we're looking to see, is this a process of, is this a natural process of price fluctuation or something else? If it is a natural process, then there is case law which confirms that you fall within the principle, and that means, for example, and that's quoting from case law, shares can plunge and then they soar again, which I think you saw in the graphs that Mark had up a few screens ago. And I think importantly, where shares are not actually being liquidated, that means that any losses are not actually crystallized. So it's actually what's happening in real terms that counts. And also for those of us who are not lawyers on the webinar today, the important question we ask for settlements that have already been reached is whether there's actually been a significant change, which means that the basis or fundamental assumption on which the order was made has changed. And I think the key reference point for us is, when would that change have taken place? And my view is that the turning point, we could measure the turning point for the lockdown in Britain as being, I would actually pinpoint it to being the 22nd of February. That was when a dozen Italian towns in northern Italy closed schools and businesses. That's very identifiable. It was a complete change. And that means if you're looking back at settlements reached in summer 2019, those are the ones we think will be capable of being reviewed. Mark, if I could just ask you to move the slide along one.
Yeah, there you go.
Okay, so just really talking about what may be important here. If we've got a settlement already in place, which is in the form of a clean break, then we know that the court will retain complete jurisdiction until any order is put into effect. That's over the period of the lockdown. And if there's been a significant change, then the court may have some jurisdiction to adjust final orders. But if there are any revisions to be made, that must reflect the underlying and original intention of the parties. But the assessment of assets, so far as deals that have already been done are concerned, must be those that were available at the trial, and that's the usual rule unless there's serious injustice to the parties. The reason why we are so concerned, and it's so important for us to reach out and check valuations on a regular basis, is because with the state of the flux, with things changing on a weekly basis, sometimes a daily basis, we're not quite sure when we can put meaningful value on investments or properties if the market is in a state of flux or freefall. So going forward, it's really difficult to predict the autumn. There's a constant malaise, I believe, about a second spike, which we can see in recent government policies. But I have to say, Mark, I'm very reassured about what you're saying about pensions. That has cheered me up no end. So I think I'm going to, I've got a question here, Mark, before I go back to you, that's been raised, which is this. How do you believe, or the PAG suggest, that pre or post-marital accrual of pension should be treated? Can they be excluded as non-matrimonial? Now, I'm going to cover that a little bit later on, but I just wonder if you could just keep that in mind about non-matrimonial assets, that is. Yeah.
There's a good bit on PAG in that I think we might cover that.
Okay.
So, but we'll come back to it if we haven't covered it by then. So just pursuing how has COVID affected us, you and your clients. We are certainly seeing more inquiries, and we're also getting some inquiries where we're partly through doing the pension sharing report, and then people are saying, oh, well, hang on a minute, the value's full, let's not go ahead. So that's why we covered a little bit about that just earlier. we are finding that response times in producing pension sharing report could, well, reduce response times. Now that's interesting. I think that's a bit of bad wording. We're finding that when we get are making our inquiries for to collate information, that pension trustees and pension administrators are taking quite a long time to respond because they're all working remotely, etc. I'm sure you've experienced all of that. So we have a bit of an issue there. I would say, certainly from our point of view, we're maintaining our turnaround times to produce a pension sharing report. Currently, we're doing, once we've got all the information we need, we are producing within 4 to 6 weeks. But we do hear, and I think this is what this point is about, is we have heard that some actuaries are so snowed under with work that they're quoting 6 months-ish to get a pension sharing report out. I think that's one reason why we've decided to be very careful about what work we take on, because we want to maintain that 4 to 6 week turnaround. Graeme's just talked through the bit about court admin, and I think we've all found it a challenge sometimes, and interesting with having meetings via Zoom and getting to grips with technology, and we're now doing Zoom meetings with clients, and I know the courts are pursuing various methods of hearings. Is that right, Graeme?
Yeah, I think that's on to the next slide, if you can just move me along.
There you go.
So I think those of us who are family lawyers in the audience know that remote hearings are here to stay. And there's been a varied response to remote hearings across the country. Certainly in the London courts, we're starting to see remote hearings used more routinely. I think at the beginning of the lockdown, it was quite commonplace for any financial remedy cases to get postponed, and the guidance from the judiciary was pretty much encouraging that. But there has been a sea change, because on the 9th of June, Sir Andrew McFarlane, our president, in the road ahead, acknowledged that we are going to have social distancing at least until the end of the year and well into the spring of 2021. And bearing in mind the amount of cases that need to be heard, that was no longer going to be an option, and therefore we are going to use remote hearings. And perhaps more concerning, he was very clear that there is going to be a need for a very radical reduction in the amount of time that the court affords to each hearing. So case management powers are going to have, there's going to be much more hands-on case management. I have to say that from my own experience of remote hearings in the Central Family Court, I think the e-judicature is working pretty well. It's not so good in the outer London courts. I don't find that BT Meet Me audio conferencing is particularly pleasant for anyone, but we do know it's a tried and tested technology. What we have seen is that paperless working is going to be the norm, and it is working surprisingly well. We are going to be having electronic bundles. I think that is the new normal. And we are using document management software better. And I think that lawyers have been able to do that work. As I say, we are now moving forward, certainly at the Central Family Court, we've gone from BT Meet Me to Skype. And I had a trial recently using the cloud video platform. There are a number of glitches, but I do believe that judges and counsel and solicitors are doing their very utmost to make it work. I have to say, though, there is a very large caveat that comes with this, which is we are in very unusual times. This was not something that happened out of choice, something that happened out of necessity. And it's difficult to see how the remote court is going to provide a lasting solution, because in the family court, we're dealing with those who've got vulnerable needs. and therefore we're dealing with the most vulnerable aspects of people's lives. So it's out of necessity. We need to embrace the technology, but also we can look forward, hopefully, in the future, at some point in the future, that we will be doing this work in person as well. Back to you, Mark.
Great, thank you, Graeme. Yeah, I think apologies because this is probably a little bit of repetition around the COVID-19. You know, valuations have fallen, property values might start falling, or might not start falling, depending on whether the recent government initiative on stamp duty is working. But investments have fallen, as we've seen, and have defined contribution pensions. My point, just to reiterate, is I don't think that's any reason to halt proceedings, because of course if you're selling a property and there's been a bit of a dip in property prices, you're buying into, the chances are you're buying into something which is equally depressed. Same with markets. Of course, you might have, we've seen this a couple of times, is my partner's lost their job or they've been furloughed, so I don't know, we don't know what's happening there. That might cause things to stall, because of course the financial future becomes a little bit uncertain. But that probably isn't any reason not to at least start the process and start gathering paperwork, because we all know how long that takes.
Okay, so back to me, and I think this just sort of rings with what Mark's saying. Certainly what he's seeing is reflected in the kind of work that we're seeing as well. And what I'm starting to see much more of is that slightly longer term, we know that there are changes in the jobs market that are going on. It's reached national news. And of course, the impact that we find is that there's going to be more variation of maintenance. And in particular, we're looking at issues arising from earning capacity, which becomes much more difficult to predict because we haven't really had this scenario before. Also, the COVID-19 disruption seems to affect a number of business sectors, and that emerges as time goes on. But some of the ones that we know it's affecting heavily are retail. We've seen the shutdown of some shops already, and I would say we're still early mid COVID-19. Also aviation and the performing arts. And we can expect other sectors to continue to be more vulnerable as the lockdown continues. Another issue we've identified is what happens in terms of private schooling, because many children are being homeschooled, and that has happened for a prolonged period. But what is the impact on schools if parents won't pay? And that in turn has effects on school fees orders. If you can just move me along one, please. Yeah, I think this may reflect back to the question that was asked a few slides ago. But it was really to point this out, that in terms of when we're doing our work in line with chartered financial planners and pension advisors, we have to have regard to what actually is going to be called into account. And under English law, as it stands, we're not in a position where we can automatically quarantine non-matrimonial property. But we do know that nuptial agreements since the Radmacher decision in 2010 have become increasingly commonplace. And my experience is that in the last few years, up to the COVID-19 disruption, it was a regular feature of my work and fellow family lawyers. And actually, I'm pleased to say that we're starting to see more prenuptial agreements and cohabitation agreements also coming as the lockdown eases. But we do know certain things are true, which is that where marriages have been longer, there are significant factors that can be called into account when deciding which property will be shared. And if wealth has been enhanced by funds received outside of the marriage, and there's greater intermingling of the funds, then it is more difficult to argue that non-matrimonial assets can be removed from account. And that, that this all comes into the court's discretionary powers to redistribute property. So that's a complex feature of our work, where we work with Mark. And I don't know, Mark, if you could go back to that question, if now's the time.
Yeah, the PAG report covers this in quite a lot of detail, and the cases that I put links to on an earlier slide also covered this. That in the opinion of the Pensions Advisory Group, that where a case is a needs case, then the courts can have recourse to all assets, whether pre or post marriage. And it also makes the point that in the opinion of the Pension Advisory Group, most cases are needs based, even where you have assets in the low millions. And I think that's what we've seen, is that in order to meet needs, you have to look at all assets, and I think all assets in a long marriage should be looked at. And so the PAG report makes that point, which has been or is being quoted in the courts now for needs-based cases. The PAG report also points out that when individuals want to exclude pre-marriage pensions, it's kind of all well and good saying that, but most clients didn't think about getting their pension statements on the date of their marriage as they were walking up the aisle, and therefore to try and work out what pensions the individuals had accrued at the date of marriage is very difficult. It's subject to a lot of guessing, and in our world, it's a straight line methodology. You're assuming that pension accrual has been on a linear basis from when they started service, and that's fraught with mathematical issues and inaccuracies. So generally, as I say, the PAG report supports looking at all matrimonial or all assets, whether pre or post marriage.
Okay, that's back to me, and I think it's just useful for us to really have a recap about why we reach out and get pensions advice, and why, as lawyers, we can't work in isolation, and we really need to have the red flags. I mean, certainly on one of Mark's earlier slides, we saw the warning of potential negligence claims. That's very real. I've seen a question asked for insurance, actually, which said if the amount of the pension pot is over £500,000, did you get a pension sharing order? So it is a very real and serious matter, and that's why I will reach out to a chartered financial planner quite early on in the process. But in terms of what we're doing as family lawyers, is we've got to look, first of all, at what is a fair outcome. And that means we've got to be within the parameters of what a court is going to find acceptable. And that, simply put, nowadays is looking at the couple's needs and sharing assets accrued during the marriage. And we have to do that exercise. We have to, as I said earlier, we have to get the quantification correct. Also, what is it our clients want us to achieve? And what are we here for? Well, what we're trying to do is something that's cost effective and efficient. Then they're going to be happy with us, and then we might get recommended or referred to other clients, and then we'll be able to enhance our practices. So it's worth having that in mind in terms of the way that we want to do our work. I think also for our clients, what we need to be mindful about is not just the end of the journey. It's not just the outcome itself. It's how the client felt during the journey. Could they afford the work that was needed? And were they comfortable with the advice that they were receiving throughout? And that's why I see it as being particularly important with working with people such as Mark, who know what they're talking about when it comes to pensions. I've just seeing some other chat points come up. Question here. I don't know if you can answer this one, Mark.
Yeah, I've just seen that.
Yeah.
I've just seen that. Thank you, Janet. Yeah, the point I should have made is Janet made the point about pre and post pension accrual and said, well, surely pension managers produce annual pension statements, which is absolutely right. They do produce annual statements, and if it's a defined contribution scheme, so where you've got a personal pension type of fund with an invested fund, you can go to the fund manager, if they still exist, which can be, and say, could we have a statement from 2010? And in some cases, the fund manager can provide them. Not in all cases, because sometimes their records didn't go back that far, or they just don't have the information. My point here, the main point here, is that defined benefit pension schemes, so final salary type pensions, might have issued annual pension statements to the individuals in 2010, but they won't have been the valuation of that scheme at that time. So the big issue we have is with final salary type schemes, which can't even, in many cases, reproduce that annual pension benefit statement from 2010, let alone the underlying value of it. So pension scheme administrators and actuaries will provide valuations for a final salary scheme now, but they won't do it retrospectively. And that's the problem. And that's the problem that we have, because then we're kind of guessing. There are ways, if people have kept salary information from when they got married, as some people do, that can help. But in our experience, people often don't keep that level of information. And of course, if, again, going back to the point, if it's a needs-based case, and it gets to court, the pre and post marriage pension accrual might well be chucked out anyway, and then you've ended up asking the person who does the pension sharing report for a piece of information which costs more money to produce that you might not really be able to use. But sorry, I hope that answers the question, that the valuations won't have been present at the date of marriage. I'll just briefly run through this, because I did this example of a defined contribution scheme and how a fall in value can affect the pension sharing outcome. Now, I'll run through it because some people say they found it helpful because it helps them understand the basic methodology of pension sharing. And here we've got a husband who had a pension fund, defined contribution, so a pot of money, a personal pension type fund. Now, I'm assuming here that they were of the same age, that they were of a very similar age, similar health, and it would be reasonable to say, if it's a defined contribution scheme where you just split it 50-50, because unisex annuity rates, which we now have, are applied to both funds. So if you had, and I'm plucking figures here really, but if you had split the husband's fund into two pots, £200,000 each, you apply a 3% annuity rate to each fund, then husband and wife both get £6,000 per annum each as a pension. In those instances, if it was as simple as that, you wouldn't even need a pension sharing report. one of the problems is the husband's pension scheme a plain vanilla type personal pension with no hidden guarantees or benefits. And also if there's differences in age and health, that can affect things. But let's say in our horrible COVID world, we see a fall by 15%, which has happened, could happen. Who knows where the economy is going? But if that happened, it means the husband's pension fund would fall to 340,000. We're assuming that the wife hasn't got any pension here. In that instance, you've got £170,000 each. Now, the other thing that's happened, of course, is annuity rates have fallen. So in this new COVID world, I'm playing a bad scenario here, falling fund value, falling annuity rate, you've now gone from a scenario which produced £6,000 per annum each to 4,700. That's there's an extra zero appeared on that 4,700. But you can see the fall in income that simple scenario has used. This is the most simple pension sharing case you can probably think of. It's when you've got multiple schemes that it looks a bit different, but that would overcomplicate this slide. Graeme, is this you or me?
I think it's you.
Okay, great. So the work we do, just to recap, we do existing case reviews. So if you've got a case where you've got a pension sharing report, let's say, and you want some assistance on it, then we can help with the pension sharing. We can help with offsetting or other capital sharing, even where clients have share options and they come into play. We can include all that work in our pension sharing reports. So our pension sharing reports often will expand to, if you like, the whole piece of sharing financial assets on divorce. We've talked about can cases be expedited or maybe deferred, and I think we have to deal with things on a case-by-case basis, but generally I don't think there's much reason at the moment to defer cases. And a lot of the work we do is reassuring clients. I've very briefly shown you the cash flow modelling, but clients, if you like, often financially they sleepwalk into divorce, and they're not quite sure how things are going to pan out. And I know I have my biases, but we can find clients get a lot of comfort and a lot of reassurance by sitting down with someone to put together, help understand what all this means.
Okay, and it's just my end piece really, and it's really to think about how we should be practicing in the future and what we're starting to pick up on in terms of trends. I'm finding that this work can be done best using the non-court options without rushing to court to issue. And increasingly it's taking place remotely. That was the case also before the COVID-19 disruption. It's also the value of using chartered financial planners in this scenario, because it's quite possible that clients will have their own separate advisors. They have to have independent advice, and they might actually be able to meet, and they may be able to reach a breakthrough as to the way forward, because it is technically difficult. It's not necessarily going to be within the ability of the family lawyer to know the answers to this. So it's work that can be done, and it actually finding a breakthrough without actually having a big bust up or adversarial argument and correspondence. Having this discussed by people who know what they're talking about is something that clients will embrace and be prepared to pay for. Also, we found that Skype mediation is something that financial planners are familiar with, and I'm finding actually in recent weeks and months that the model of hybrid mediation is starting to come to the fore. It is being promoted by Resolution at the moment. I'm involved in one as well, and that has the benefit of lawyers and family law professionals appearing alongside their clients, providing that level of reassurance they need. Using collaborative law, or the principles of collaborative law, is known to actually provide the highest client satisfaction rates. And that's again, it can be a very good use of a chartered financial planner and can be used as a neutral in that scenario. And also quite topical is the process of early neutral evaluation, which is really getting an early view from counsel on an issue. But this can be well informed by a chartered financial planner. And the benefit of that is if there's a real concern about legal fees and there's constraints on the purse, that you can get that answer before your clients have a heavy outlay. So they feel that they're getting what they're paying for. And finally, I do think that arbitration is going to become more popular. It is I suppose, a sort of privatization of law. And although we're still in the beginnings of that, I do think that where we're looking at technical points, and there can be technical points when it comes to pensions, that using written submissions might actually be the way forward to getting a relatively quick and satisfactory answer to all of this. In conclusion, as we're coming towards the end of today's webinar, I just wanted to reach out and say many thanks to Mark for sparing his time and to demonstrating his wisdom and expertise about financial planning and divorce. And I'm hoping that this will provide some pointers as to when a chartered financial planner can be usefully engaged when it comes to negotiating and also litigating financial remedies. I also want to say thank you to all the participants for watching the webinar today. I'm happy to say that the participants list kept up the same level, so people were able to watch throughout. And this is being recorded live, but it would also be available to view on demand soon. So thank you very much to everyone.
I think I just before we close, I just wanted to mention, Graeme, you mentioned there about collaborative law, and that in Bluesky there's 3 advisors, chartered financial planners. We're all members of Resolution, oh, we've lost our slide. We're all members of Resolution, and so we can sit in as what they call financial neutrals in that meeting, so we can be used for that.
Yeah.
And are we done now?
Yeah, no, it's just a point that was made by my colleague Peter Martin, that if you're thinking about arbitration, that actually solicitors can often be a useful person to contact, as opposed to retired judges, simply from their knowledge of practice to have the use of the arbitration option. But thank you very much, and I think we're done. Thank you, Mark, and thank you everyone for watching. Bye-bye.
Thanks, bye.